Your Lordship, I beg to mention item number 15 of the hearing list.
15. Okay. Yes.
Your Lordship, if this matter can come up on 26 of 2025.
26th.
Yes.
Learned Government Council, UCAIME has paid for listing the matter on 26th of June. For hearing.
20, Your Lordship, 20.
20. On what ground?
Your Lordship, I have some personal difficulty today.
As she has some personal difficulties today. Learned Council for the petitioner has no objections, list on 26.
Much obliged, Your Lordship.
Mr. Lordship, I beg to mention admission item 3 and 4. Here, I'm here to file affidavit in reply.
3 and 4.
Yes. I mean, we granted 3 weeks time to file affidavit in reply to the counter filed as the respondents.
Counsel for the petitioner, Mr. S. Walling, has prayed for 2 weeks.
3 weeks,
3
Lordship.
weeks time to file an affidavit in reply to the affidavit filed by the state respondents. So prayer is allowed. Is the matter of the 3 weeks. Learned government advocate M. Longcom is present.
Obliged. Obliged.
My lord, I beg to mention item number 14. It is a consensus prayer that the matter be listed on 1706.
17th, next month, next week.
06.
List the matter on 17/6/2025 on the prayer of the parties. Yes. No objection.
Obliged, my lord.
Yes.
May I pledge your lordship?
Yes.
My lord, I beg to mention item number 5. I have to file a reply to the affidavit of opposition, my lord, so that this matter will come out after 2 weeks.
Counsel for the petitioner, Shri Zetan Moli, has prayed for 2 weeks' time to file a reply to the affidavit in opposition filed by the state respondents.
Yes, and as well as the
State
practice.
respondents, as well as the respondent number
Yes. 4 and 5.
4 and 5. Stop prayers allowed, list after 2 weeks.
Yes.
2 weeks or 3 weeks? What did I say? 3 weeks.
2 weeks.
2 weeks.
But in this issue, I have raised a preliminary objection regarding the maintenance of which petition also.
Okay, we'll see.
My lord, again, I beg to mention item number 16. On behalf of Young Gauhati,
Yes,
let this matter come up after 2 weeks.
3 weeks.
Yes, my lord.
Your Lordship, kindly this matter may be listed on 19.
They are praying for 2 weeks.
Yes,
Why? He's not well or?
yes,
my mention has been made on behalf of Mr. Young Gauhati, learned CJC, to list the matter after 2 weeks as the learned council is indisposed. After 2 weeks will be, it is, okay, list the matter after 2 weeks. Yes. Last week.
May I please, Your Lordship? Lordship, I beg to mention item number 2 on behalf of Eileen Mason.
Item 2.
Yes, Your Lordship. Yes. She's going under medical treatment, so can you list this matter after vacation?
Who?
Any Mason, the
An-
leading counsel.
Okay. MS Krulu has prayed for listing the matter of after the summer vacation as the leading counsel. MS Annie, what?
Any
Annie
Mason.
Mason has some difficulties today. And that you are for?
For the respondent, my lord.
Learned counsel for the respondent has no objection. List the matter after the summer vacation.
Lordship, there's interim
The
may
interim
continue.
order passed earlier shall continue till the next date.
Maybe, Your Lordship, I beg to mention item number 8.
Item 8.
Yes.
Yes.
Your Lordship, on the previous occasion, we have filed our bakalan nama. However, we are yet to file our objection. As such, 3 weeks time may be allowed to file for objection.
Learned counsel such and such appearing for the respondents. Respondents, which respondents?
Respondent number 1,
Respondent number 1. And has prayed for how much time?
3 weeks time.
3 weeks time to file objection. Stop. Prayer is allowed. List the matter after 3 weeks. Learned counsel for the appellant. Such and such is present. Yes.
Much appreciated, Lordship.
Please, your ladyship,
Yes.
I beg to mention item number 7.
Item 7, yes.
Can you grant us 3 weeks time to file our objection to the IA?
You're mentioning
For
as
respondent 4.
for respondent 4. Learned counsel, Ms. Such and such, appearing on behalf of respondent number 4, has prayed for
3 weeks
3
time.
weeks time to file a reply
Objection to the IA.
objection to the IA. File an objection to the IA. Number, this is 32 of 2025. Okay. So, prayer is allowed. List the matter after 3 weeks. Learned counsel, such and such appears for the petitioner and.
Your Lordship, I'm for the
Counsel
state. Your
Viveka
Lordship,
appears
I'm
for
also
the
yet
state.
to file my affidavit.
The learned counsel for the state respondents, Ms. Livika, is also yet to file affidavit. And that's all.
For applicant.
Yes,
You
it's
have it.
reported. Okay.
Much obliged.
For admission, item number 1.
Yeah, please, Your Lordship. Lordship, here I'm mentioning on behalf of my engine for respondent 1 and 3, Lordship. Lordship, I have instruction that if this matter can come up after 2 weeks, Lordship.
My lord, I have a prayer. I've prayed that this matter may be taken up. Only a short time may be granted because this is pertaining to 2023. And then this honorable court has directed the respondents to consider the case of to regularize the service of the petitioner in terms of the OM 17 March 2015.
17 March.
Yes, of the completion of 30 years of service. And then his case
That
without
work charge.
Yes. And then as per the OM, those cases whose case cannot be considered for regularization as on 17 March 2015, their cases has to be taken up in batch wise, that is on 1st of July and then 1st of January. Now, first, the order was passed on 10/11/2022. Now, after 10/11/2022, after the order was passed, 2023, January, July
July.
have gone. 24 also, January, July has gone. Now 25 also, 25 January is already gone and July is approaching.
Now July. is-
Yes, so that, because considering the OM, this honorable court has directed to regularize the service of the petition in terms of the OM.
Then Lordship, in that view of the matter, Lordship, Lordship, if this matter can come up next week, Lordship, I'll inform the council.
Yes, who is appearing? You were saying?
More mention for respondent 1 and 3.
Government Council, Ms. Imomi has prayed for listing the matter next week
Next week.
as the learned counsel, Mr. Mua Imchen, appearing for respondent 1 and 3 has some difficulties
Lovely.
today. Learned counsel for the petitioner submits that the petitioners were work charge employees and this court had directed that their services should be regularized. As per the memorandum, what is that?
13 March 2015,
Yes.
page 14, Annex A.
As per the office memorandum dated 17 March 2015. It is stated that as per the office memorandum, the regularization of work charge employees who have completed or will complete 30 years of continuous service will be taken up in 2 batches as on 1st July and 1st January every year. Stop. It is stated that this petition was filed in the year 2023 and accordingly 2 years have already passed, and in 2024 the first batch as on 1st January has already been taken up. Stop. And now the second batch will be taken up with effect from 1st July. And therefore there is some urgency in this said matter. Stop. It is made clear that an endeavor shall be made to. Let's see that the state respondents will make an endeavor to dispose the case of the petitioners.
Obliged.
For admission, item number 6.
Lordship, I'm mentioning on behalf of my senior Moy Imchen Lordship. Lordship, I've been instructed that he is yet to receive, he is yet to file affidavit in opposition, Lordship. If Lordship be pleased to grant
Last
2 weeks time.
occasion, 27/5 also same thing. He said that it has been sent for vetting and therefore please for time. Okay, 2 weeks.
2 weeks time.
Government Counsel Vijay appearing on behalf of Mr. Moy, learned senior government advocate, prays for 2 weeks time to file the affidavit in opposition as it has been sent for vetting. There is allowed, at least a matter of the 2 weeks. Learned counsel for the petitioner, Moy General is present.
Obliged. For orders, item number 9.
Service on respondent 5. Is anyone appearing for respondent 5?
No, madam.
No one.
On the last occasion, your lordship, when the matter was listed on 22/5,
Yes.
notice upon the respondent number 5 was still awaited, my lord.
Now it has been served. 10/6/25, it says tracking report of notice issued on respondent 5 indicates that delivery has been confirmed
Lordship,
on 16/4/2025.
lordship.
Who is respondent 5?
Lordship, I think,
Shui Muhammad Ali
Insurance
Stihab.
Secretary, yes. PNR. But I think, oh no, he's still there. Is he still there, PNR?
lordship, I guess so, your lordship.
Then what happened with that case? Learned counsel for the petition is present. Stop learned counsel and Nangami is present for the respondent number 1.
My lord, I'm appearing for respondent number 3.
Tipapong appears for respondent number 3. Office note dated 10/6/2025 indicates that notice on respondent number 5 has been delivered. However, none appears for the respondent number 5 when the matter is called. Stop. We'll just give them some time, 2 weeks, list the matter after 2 weeks. Awaiting the appearance of respondent number 5.
Obligement.
Much older. Obligation. For orders, item number 10.
No revision.
Lordship.
Here also service awaited. Petitioner.
Lordship,
Yes.
Lordship, this criminal revision petition has been filed by the state respondent, Lordship, selling the
Oh, okay.
Lordship.
Current government advocate, Mr. V. Momi is present for the petitioners. Stop. Office note dated 16/5/2025 indicates that return service report is still awaited. Stop. Today, when the matter is called out, there is no further information regarding the return of service report. Stop. Accordingly, it's the matter after 2 weeks, awaiting service report in respect of respondent number 5. Respondent number 5 or sole
Sole
respondent?
respondent. Sole respondent.
Sole respondent.
Obliged. For orders, item number 11. May I please, my lord? Lordship, I have instruction to appear for respondent number 2 in this matter. However, your lordship, respondent number 2 no longer holds this office, your lordship, he has been transferred. There's a commissioner and secretary PhD department, my lord.
And what about 1 and 3 represented?
Not yet.
No, your lordship.
In the meantime, Your Lordship, respondent one,
Okay,
actually notice be awaited and
Then
And
for
the-
2, you'll have to
yes, I'll file an
take
I.
steps. Learned counsel for the petitioner is Walling is present. Stop. Learned counsel.
Nangami for.
I get so mixed up.
Lordship.
Nangami is present for respondent number
2, my lord.
However, it is submitted that the respondent number 2 has been transferred out from the PhD department. Stop. Notice on respondent number 1 and 3 is still awaited. Service report on behalf of respondent 1 and 3 is still awaited. Stop. The petitioner shall take steps for implement of the new incumbent in the PhD department. Stop. How much time will it take? 2 weeks.
2 weeks.
Within 2 weeks. This after 2 weeks.
Obliged.
Deeply obliged, my lord. For orders, item number 12.
Yes. Nisuka Chishi. None appears for the petitioner when the matter is called. Learned PP, Mr. K. Ngam is present. The petitioner was directed to file an affidavit on the dusty service made on respondent number 2 and 3. the same is yet to be filed. So this is the matter after 2 weeks.
For orders, item number 13.
Item 13 is hearing only.
For hearing.
There's one supplementary. items. Item 20, I think.
Please, my lord. Lord, I'm appearing through VC.
Yes.
Am I audible, my lord?
Commission. Okay.
Please take an hour.
Oh,
It's been brought.
yes, this is item 20.
Please, my lord.
Actually, it's, see, I have been supplied a number of notifications issued by the Gauhati High Court. So what is happening here is, on previous occasions, usually the senior most judge of the bench is nominated as the bench to deal with arbitration matters, including appointment of arbitrators.
Please, Lord.
Yes, so there's an order of 17 August 21. Similarly, in Itanagar, Aizawl also, the principal seat nominates a certain judge, the senior most judge of the bench, to deal with arbitration matters.
Please, Lord.
You
Please,
got the
Lord.
notifications?
No, I've not seen that.
I was just given this morning
Okay,
only.
okay.
So, the last order of Kohima bench was Justice Serto who was nominated as the judge for to deal with the appointment of arbitrators.
Okay.
And after this, there's no order.
Okay.
And usually what happens is the senior most judge of that particular bench is appointed. Of course, in Gauhati is a different matter. In the principal seat, they appoint one of the judges.
Okay.
So I think certain clarifications need to be made by the registry with regard to this.
My lord, once we both are agreed for the, my lord, any learned retired judge of this honorable court, and
No,
we
no,
will
no.
not be having any objection.
No, it's not that. There is a
I
panel.
know.
Also.
Yes,
There's a
yes.
panel. There's a panel. And have you got a copy of the panel?
Yes, panel, my lord, I have also received.
Yes, there's
That
a
is
panel.
21st of May, 2024.
24, I think.
This is the, my lord, panel of arbitrators.
I also have it. 4th August 2023.
No, my lord, this is 21st of May, 2024, notification number 29.
Then, okay.
In partial modification of this registry and earlier notification number 99 dated 4th of August 2023, the Gauhati High Court has been pleased to reconstitute the panel of arbitrators in the following manners.
I only have
So-
the 4th
So this is the partial modification of the notification dated 4th of August 2023.
But anyway, when the precedent is there that the senior most judge is appointed is nominated, I think certain clarifications are required from the principal seat. So I will just pass an order accordingly and let the registry take steps.
As
Okay.
my lord.
Yes.
So Milord is saying that as per the notification of 4th of August 2023, the arbitrator is to be appointed by the senior most judge.
Yes, yes. Whoever is the senior most judge presiding in the bench at
Okay,
that,
my lord.
or they nominate. It is specifically nominated by an order by the Gauhati High Court.
Please,
particular
Lord.
judge
Yes,
by
yes,
name.
yes.
Hmm.
Please, Lord.
So in view of that, I think this court cannot pass the order unless a nomination order is there. Yeah. The Gauhati High Court by order number 27 dated 17th August 2021 had nominated Honorable Mr. Justice S. Serto to deal with arbitration matters, including appointment of arbitrators at the Kohima bench of the Gauhati High Court. Stop. Are you also aware of any other order after this?
No, my
No.
ladies.
It appears that subsequently, after the retirement of Honorable Mr. Justice S. Serto, no other judge has been nominated at the Kohima bench. Stop. The registry is directed to coordinate with the principal seat and place the necessary instructions before this court list after 4 weeks.
Please, Lord.
The date be fixed, your lordship.
Okay. So then it will come up after vacation, I think.
Lordship,
Yes, ma'am.
15th.
15, your lordship.
Lord, I'll just check. 15th of August. 15th of July, my Lord.
15th of July. 15th of
Please, Lord. Great. Lord.
For hearing item number 13.
You ready?
Petitioner represent from Dimapur. So I don't see the petitioner here today.
Yes, please, Suryan. Pakrin Chabu normally is very regular.
Actually, B. Suren is a leading counsel.
The counsel for the petitioner is not present when the matter is called. So learned additional AG in Tim Song is present for the state respondents. List the matter
On 24th of this month,
on
Tuesday.
24/6/2025.
For hearing item numbers 17 and 18.
Yes.
May it please, your lord.
Yes.
Here, the two petitioners are seeking posthumous regularization of their husband. Now,
Posthumous regularization of
yes,
the husband.
husbands,
Deceased-
they,
deceased
yes,
husbands.
they expired.
Hmm.
Now there is a,
They expired well in service.
while in service, they were appointed as work charge,
Hmm.
but they were not also put under the muster rolls. But when they were getting scale of pay, your lordship,
Hmm.
there is one judgment which I would like to take your lordship to, it was passed by the Honorable Apex Court.
Hmm.
It's at page 38 of the WPC 332.
Page 38. Civil appeal 4223.
Yes. In the other also I have, it is annexed. Now here, the Honorable Supreme Court has held in one case that
Hmm.
the deceased was, cannot be granted posthumous regularization. But then paragraph 4.1, page 42.
Yes.
It is required to be noted that a deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein, original writ petitioner, wife of the deceased employee, claimed the regularization after a period of 12 years from the death of the deceased employee. At the time of the death of the deceased employee, he was not entitled to regularization as he was much below in the list of the work charge employees whose services were to be regularized. Under the regularization policy, the services of the work charge employees were required to be regularized as per the seniority and as and when the vacancy arises. The services of the other work charge employees, even who were senior to the deceased employees, were regularized in the year 2009. That is after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the service of the deceased employee 1 day prior to his death, which otherwise his services were not required to be regularized as his turn had not come, and he was much below in the seniority list. Considering the aforesaid facts and circumstances, the impugned judgment and order passed by the High Court is unsustainable and the same deserves to be quashed and set aside. So the ground on which this judgment was passed is that the husband of the petitioner was not even in the senior, was much below the seniority list, and even he could not, during his lifetime, he made no application. And at the same time, he could not have been regularized at that point of time. That is the ground on which this decision has been passed. Now the state is seeking to apply this in all cases. But in these two cases, senior persons who were junior to the petitioner's husbands were regularized prior to the demise of the petitioner's husband. That is our main case. So this judgment, this judgment cannot be applied because the Supreme Court has also made it very clear. If this is to be interpreted in its proper light, then in this case, in these two cases, this cannot be applied. In this case also, had juniors been regularized, then it is obvious that the Supreme Court would have allowed this Honorable High Court's judgment. So based on that, I am now going to submit the facts.
So the Supreme Court passed this order on the premise that the other work charge employees who were regularized were senior to the deceased employees, and they were regularized after the death of the petitioner's.
Yes, that was the rationale. I have. So the petitioner's husband.
This is for family pension only, isn't it?
Family pension only.
So Rule 54, I think, of the CCS pension rules, which the state is following.
Yes.
It talks about family pension. So doesn't it say that even if an ad hoc employee, if it's an ad hoc employee, someone who has worked for even 1 year,
yes,
the family will be entitled to family pension.
Yes, but here in this case, this is work charge. So the Supreme Court has in many instances held that work charge employees are not. But in the case of the work charge employees, there is the Work Charge Act, Work Charge and Casual Employees Act of 2001, I believe. So under that, various notifications have been issued.
Okay.
For
Anyway.
regularization.
Yes.
So the petitioner's husband This petition was initially filed by Ms. Sandila, who unfortunately expired.
Mm, mm.
Page 21 is the initial appointment order of the petitioner's husband. This is dated 6th April 1989.
Mm.
He was appointed as overcharge labor
On
and
fixed.
fixed pay. Then page 23, the typed copy is at page 24. It is not very clear. Page 24.
Mm.
This is dated 6 June 94. Now by this, he was promoted to Chukali in the scale of pay of rupees so and so per month. Now, service is purely temporary and liable to terminate without notice. Now, by this, it appears that the promotion, with the promotion, his service was converted to temporary. It is not work charge.
Mhm.
Now, service books, service copy, the service book is also annexed here too. Now, the date certificate.
Mm.
Date certificate is at page 31. So he expired on 25/4/2015. The petitioner's representation is at, there are several representations. The petitioner's first representation starts from page 32. So upon his demise, the wife submitted this representation for praying for regularization of his service and to grant her family pension. Again, this is stated 3/9/2015. And the second representation is 14/2/2020. And the third representation is 23/5/2023. Now, Your Lordship, subsequently, since the department was sticking on the judgment of the Honorable Supreme Court,
Hmm.
which I had already taken your lordship through.
Hmm.
An application was submitted under the RTI seeking the seniority list and the persons who have been given regularization in service. So by this page 35, this is 1st April 2023, RTI reply was furnished. Here there is a list of persons who were regularized. These are all work charge regularizations. So all the date of appointment is given, as your lordship will see in the middle. Designation, all these are the persons who are regularized. And all of them are, in fact, were appointed subsequent to the appointment of the petitioner. There is also another seniority list which was furnished to the second one, which is more detailed. But I'll come to that. But here it is obvious that all these persons who were regularized, and all of them were regularized between 2008 and 2014.
They are all junior.
They are all junior, they were all appointed subsequent. It is very much obvious.
Hmm.
So considering this aspect of the matter and the fact that the Honorable Supreme Court has also clearly laid down that had not banned every kind of regularization, posthumous regularization. Only in this case, because of the fact that the petitioner's husband was not entitled to regularization during his lifetime, and even his seniors were given regularization after his demise. So he cannot have the right to regularization. That was the stand of the Honorable Supreme Court. And this case cannot be applied blanket in our case. That is my only submission. So in our case, since juniors had been regularized during the lifetime of the petitioner's husband, he should be regularized for family pension. That is my humble submission before this Honorable Court. The second case also is
Same.
more or less same. Here, the petitioner's husband was appointed on 15/5/1992. Initial appointment. I'll take your lordship to the page 24.
Annexure 6.
Annexure 6. Yes. The type copy is at page 25. He was appointed as work charge plumber helper. This is 20th September 1993. 20th September 1993. Service book follows. And in his case, after representation was submitted, he approached this Honorable Court by way of a writ petition, which is the order of this Honorable Court is at page 32, Annexure 10. So the direction was issued to consider the representation of the petitioner within a period of 2 months. Page 35, the now, page 37, Your Lordship, annexure 12. This is the decision taken.
Yes, what does it say?
It says, this is 22nd of February 2022 to the petitioner, that is, and then subject WPC number 238/2021. So and so. In reference to the above cited subject and in compliance to direction of the Honorable Court Order dated 15/11/2021, the department had examined your representation dated 31/8/2021, requesting for posthumous regularization of your husband, late Junipra Lohi, work charge plumber helper for pension benefits. However, there is no government policy for granting posthumous regularization to work charge employees. And in absence of a government policy for such consideration, the department is not in a position to consider your case. That was the decision. And page 38 is an application for review of the decision. So in the meantime, the judgment of the Honorable Supreme Court also came out. So now the petitioner sought information under the RDI Act, which is at page 41, annexure 14. This is dated 5/6/23. So the reply was furnished by letter dated 3rd July 2023, which is annexure 15.
Page 42.
Yes. 3rd July 2023. Now, Your Lordship, all this are the employees who were regularized from 2004 to 2020.
Your juniors.
Yes. Bearing one or two, all are juniors. My humble submission before this honorable court is that in essence, juniors were. And he expired in 2023, 6/3/2023. So
Six 3/2020 or 23?
6/3/2023. Oh, 2020,
in
it
the-
should be, yes,
in
it should
the
be
certificate,
2020.
yeah.
I'm sorry, yes, it is 2020.
Certificate, it is 6
Yes.
weeks.
In the synopsis, it has been wrongly typed. 6/3/2020. So my humble submission is, since juniors were regularized while they were still in service, a distinction can be drawn between the facts of the case which was obtaining in the civil appeal number 4/2/23 of 2022 before the Honorable Supreme Court. And the Supreme Court has also made it very clear that since in this case, juniors were not regularized, he was in the seniority list far below, and he could not have been regularized at the relevant point of time when he expired. Because of that only, the Honorable Supreme Court has interfered with the decision of the Honorable High Court. But in this case, during their service, during their lifetime and while they were still rendering service, all these juniors were regularized, bypassing them. So in this case, the husbands of the two petitioners are entitled also to be regularized posthumously, at least for the purpose of pensionary benefit. That is my humble submission before this undergoes.
Yes. My pleasure, Lordship. Lordship, may kindly come to my affidavit, page 3, paragraph 9.
Page 3.
Lordship. Page 3, 9. If I may be allowed to read, Lordship. That with regard to the statement made in paragraph 12 of the writ petition, the answering deponent respectfully state that though the petitioner husband case is covered by the office memorandum dated 17/3/2015, but he is not eligible for regularizations since it has specifically mentioned that all existing ward charge and casual employees who are enjoying scale pay and who have completed 30 years of continuous service are eligible for regularizations of service. That is in Lordship Annexure 2 of the writ petition, Lordship. However, Lordship, the petitioner husband was in service for 26 years and expired on 25/4/2015. Further, there is no government policy for posthumous regularizations of work charge employees for pensionary benefits. Therefore, his case cannot be considered. Lordship, now paragraph 11. That with regard to the statement made in paragraph 15 and 16 of the writ petition, the answering deponent humbly state that the petitioner husband was at serial number 19 in the seniority list of work charge employees as on March 2015. He was working habitually for 26 years and expired on 25/4/2015. It is also further stated that the petitioner husband has never submitted any representations for regularizations of his service to the respondent during his lifetime, and the petitioner submitted the representations only after the death of her husband with a delay of 4 months. Lordship, it is submitted that the present case is a cover case by the judgment of the Supreme Court dated 11/7/2022, the state of Nagaland and others versus Nishibi Achumi. To quote Lordship, para 4.1. If I may be allowed to read, Lordship. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularizations. That the respondent herein original writ petitioner, wife of the deceased employee, claimed the regularizations after a period of 12 years from the date of the deceased employee. At the time of the date of the deceased employee, he was not entitled to regularization, as he was much below in the list of the work charge employees whose service were to be regularized under the regularization policy. The service of the work charge employees were required to be regularized as per the seniority and as and when vacancy arise. The service of the other workers employees, even who were senior to deceased employees, were regularized in the year 2019, that is, after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the service of the deceased employee one day prior to his death, which otherwise his service were not required to be regularized, as his turn had not come, and he was much below the seniority list. Therefore, it is the submissions of the answering deponent that the Lordship, the same yardstick should be applied in the present case, Lordship.
But the facts are slightly different in this case. Because his juniors had already been regularized before he died. So the facts are slightly different.
And Lordship, in the PPC 331, Lordship. In my affidavit, page 5.5. If I'm allowed to read, Lordship. That with regard to the statement made in paragraph 3 of the writ petition stating regularizations of two workers employees are admitted. However, there was no vacancy of plumber helper. As such, no plumber helper was regularized. And Lordship, paragraph 8, page 3. That with regard to the statement made in paragraph 10 and 11 of the writ petition, the answering deponent respectfully state that the petitioner husband led Zender Bro Lohe after becoming senior most among the workers plumber helper under Executive Engineer Division number 1 Kohima. There was no available regular vacancy to regularize his service. As such, his case could not be considered during his lifetime. As stated in office memorandum dated 22/9/2004, clause 2, regularization of workers employees will be done against available regular vacancy, that is in Annexure 1 to the writ petition, Lordship. It may be further stated that though the petitioner husband case is covered by the office memorandum dated 17/3/2015, but he is not eligible for regularization since it is specifically mentioned that all existing work judge and casual employees who are enjoying scale pay and who have completed 30 years of continuous service are eligible for regularization of service. That is in Annexure 2 to the writ petition. However, the petitioner husband was in service for 27 years and expired on 6/3/2022. Therefore, his case cannot be considered, Lordship. And Lordship, also, since during his service, he never submitted any representation for regularization, Lordship. And he served only for 27 years. Lordship, on the last occasion dated 27/2/2025. After a lengthy hearing, the Honorable Court has also passed an order. So if I may be allowed to read, Lordship.
Order dated
27/2/2025. Last paragraph, Lordship.
7/2. Yes.
Last paragraph, Lordship,
Yes.
if I may be allowed to read. On considerations of the submissions and the perusal of the judgment, this court is of the prima facie view that the decisions of the Honorable Supreme Court in the Shivi Achumi case appears to be covered the present case. However, on the instance of Mr. Tombok Pongener Learning Counsel for the petitioners for addressing this court, and due to vacancy of time, the matter is adjourned, Lordship. So, Lordship, this case is clearly covered by the Nishivi case law.
We just study it. Would you like to reply?
Your Lordship, this was during adjournment only. Merit was not gone into, Your Lordship, in this case. So,
The court said prima facie. Prima
yes,
facie, it appears.
yes, so,
No, we'll have to study it.
yes.
Counsel for the petition.
I would like to place one, this is also a recent Supreme Court judgment with regard to exploitative engagements. Here, the Honorable Court has, though the facts are not, the facts are different here. Here, these are like work charge and casual employees who were being employed for long periods of time and then their services were dispensed with.
Hmm.
They approached the Honorable High Court. The High Court dismissed the petition, but the Supreme Court has held that no, you cannot do that. You cannot exploit them, and the Uma TV case does not apply in this case.
Hmm.
So this also may help. And so
Long serving means
these were,
how many years?
yes, I'll give you, I'll just give you some, one. Paragraph 14, if, paragraph 14, page 16.
Yes. The respondent employer, this one.
Yes, the respondent employer places reliance on Uma TV Supra to contend that daily wage or temporary employees cannot claim permanent absorption in the absence of statutory rules. Here we have statutory rules providing such absorption. However, as frequently reiterated, Uma TV itself distinguishes between appointments that are illegal and those that are irregular. The latter being eligible for regularization if they meet certain conditions. More importantly, Uma TV cannot serve as a shield to justify exploitative engagement persisting for years without the employer undertaking legitimate recruitment. Given the record which shows no true contractor-based arrangement and a consistent need for permanent horticultural staff, the alleged asserted ban on fresh recruitment, though real, cannot justify indefinite daily wage status or continued unfair practices. So ultimately, page 20, from page 21, Your Lordship, page 21, paragraph 18, downwards. The impugned order of the, if I may read.
Yes.
The impugned order of the High Court to the extent they confine the appellant workman to future daily wage engagement without continuity or meaningful back wages is hereby set aside with the following directions. One, that is continuation of the appellant workman services effected without compliance with Section 6E and Section 6N of the UB Industrial Disputes Act 1947 is declared illegal. All orders of communications terminating their services are quashed. In consequence, the appellant workmen shall be treated as continuing in service from the date of their termination for all purposes, including seniority and continuity in service. The respondent employer shall reinstate the appellant workmen in their respective posts or posts akin to the duties they previously performed within 4 weeks from the date of this judgment. Their entire period of absence from the date of termination until actual reinstatement shall be counted for continuity of service and all consequential benefits such as seniority and eligibility for promotion, if any. Considering the length of service, the appellant workmen shall be entitled to 50% of the back wages from the date of their continuation until their actual reinstatement. The respondent employer shall clear the aforesaid dues within 3 months from the date of their reinstatement. 4, the respondent employer is directed to initiate a fair and transparent process for regularizing the appellant workmen within 6 months from the date of reinstatement, duly considering the fact that they have performed perennial municipal duties akin to permanent posts. In assessing regularization, the employer shall not impose educational or procedural criteria retroactively. If such requirements were never applied to the appellant workmen or to similarly situated regular employees in the past, to the extent that sanctioned vacancies for such duties exist or are required, the respondent employer shall expedite all necessary administrative processes to ensure these long-time employees are not indefinitely retained on daily wage contrary to statutory and equitable norms. Here, in this case, there was no statutory rules. In our case, there is a statute. which governs regularization. 50% of regular vacancies arising every year. Work charge promotion, regularization for work charge employees is reserved for the first 50%. The other 50% is for direct recruitment. That is the clear policy. Now, work charge employees means these are multitasking staff. They cannot say that since this post has a different designation, we'll regularize this person who is holding this, so though he is junior. No. Whenever vacancy is right, it has to be on seniority basis. What they are saying now is that vacancies arose, post was not, the
Number-
nomenclature of the post
Number
was.
post was. not
Yes,
there.
yes, but that is not an excuse. So juniors have been regularized all these years during his lifetime. So that is the distinction I would like to.
Counsel for the petitioner, Sultan Kupono, and Ms. Peter Mukitan, for the respondents, notice received.
I oblige.
For hearing, item number 19.
Please, your lordship.
Yes.
Lordship, this matter is for a conventional appointment. Here, the petitioner is in serial number 1, and she is the only person to be appointed. And she'll be appointed when her turn comes up. Since now the department has less of vacancy, so she'll be appointed when the vacancy is arising.
Hmm.
In my affidavit, batch 2, bara 5, sub bara 5.
Hmm.
Now the petitioner is recorded in the serial number 1 in the seniority list of the applicant for appointment on compassionate ground. Therefore, the case of the petitioner can be considered for her appointment on compassionate ground as when her turn comes. And her annexure that which the department have sent is in the annexure A, page number 5. Page 5, annexure A.
Okay, we'll dispose it of then.
Yes, Lordship,
Yes.
with the direction to consider my case when vacancy arises.
When the next vacancy arises.
Yes, Lordship. To any grade 3 posts where I'm
Grade three.
eligible. Yes, Lordship.
Grade 3 or 4?
Grade 3, I'm eligible. Not
Grade
mentioned,
three.
Your Lordship. PSC.
Okay.
PSC.
This petition under Article 226 of the Constitution has been filed by the petitioner praying for compassionate appointment under the establishment of Nagaland Science Center under bracket NSC, close bracket, Dimapur, Nagaland. Stop. Next part. The facts of the case is that the petitioner's father was working as a regular electronic technician under the establishment of Nagaland Science Center, NSC, Dimapur, Nagaland. Stop. He died in harness on 28/10/2023, leaving behind his wife and 2 daughters. And he was the sole, it's okay, you can sit, and his 2 daughters. Stop. He was the sole bread earner of the family. Stop. It is stated that the petitioner is a BSc graduate with a diploma in computer application. And accordingly, she is the daughter, the
Yes, ma'am.
petitioner is the daughter of the deceased employee. And she is a BSc graduate with a diploma in computer application. Stop. Accordingly, she applied for appointment as per the compassionate scheme. Have you enclosed the scheme?
Yes, Lordship. The scheme is at
As
page
per the
17.
scheme.
page 17 is the OM. OM dated September.
Compassionate Scheme of the Government of Nagaland, White OM number AR-8/8/78, dated 17 September 2015.
And also the addendum,
And also the addendum
page 19.
addendum number AR-8/8/78, dated 9th April 2019. Stop. The petitioner had therefore submitted an application dated nil and another reminder dated 29/10/2024. Stop. However, the authorities did not consider her applications for appointment on compassionate ground. Being aggrieved, the petitioner has approached this court. Stop. I have heard learned counsel for the petitioner, Shri Arun Long, and Mr.
Ajung Lee.
Ajung Lee
Sangdam.
Sangdam, for the government advocate for the state respondents. Stop. At the outset, the learned government advocate has drawn the attention of this court to the paragraph 5 of the affidavit in opposition filed by the respondents number 1, 2, and 3. Stop. Next paragraph. In paragraph 5 of the affidavit in opposition, comma, the respondents have stated that the petitioner's name is recorded as serial number 1 in the seniority list of the applicants for appointment on compassionate ground. Stop. Therefore, comma, the case of the petitioner can be considered for appointment on compassionate ground as and when her turn comes. Stop. However, as there is no vacancy at the moment, comma, her case has been enlisted and compiled to be taken up as and when clear vacancy arises. Stop. In support of this statement, comma, the government respondents have annexed a letter number, capital letters, SNT dash 184/2024 slash, this is 21. Your
It appears
letter,
so.
your letter,
It appears so.
slash 21, dated 7th February 2025, comma, which is a letter addressed to the Principal Secretary, Science and Technology Department, Nagaland, Kohima, from the Director of the Science and Technology Department. Stop. In this letter, the petitioner's name has been forwarded for appointment on compassionate ground as maintained by the department. Stop. Next paragraph. The petition is accordingly disposed of with the following directions. The petitioner, the state respondents shall consider the case of the petitioner for appointment in the next grade 3 vacancy which arises, as the petitioner is qualified, educationally qualified for the same as per the office memorandum dated such and such, that earlier scheme. Okay.
17/9/15
17/9/15.
and addendum 9/4/19.
With the above directions, this petition stands disposed.
Much obliged.
Toshi, Kevin, Consider. Itu. Ini lah,